authority closest to the person. We won't put it in some distant guardianship office. We'll put it closest to the person, people who trust, know this person well enough, and we'll leave the discretion up to them to decide whether to support or substitute. So that we resolved what we thought was a major problem with the principle of subsidiarity. We brought it as close to the person as possible. We've said it's in the context of a trusting relationship, and yeah, they're going to have some discretion, but that's okay. And again, I don't think that solves the problem, because I think there is a distinction to be made between supported and substitute. And I think, as Rob said yesterday, if we had 4 hours, maybe we could have taken it further. And I think unless we draw a distinction, and the problem is all the legislative models that we're seeing now, whether it's the BC Representation Act or most of the other legislation in Canada, as I understand the system in Sweden, in Germany, the draft legislation in Ireland, all of them sort of operate on that kind of principle of subsidiarity. Let's get as close to the person as possible, and we'll leave the discretion up to them. The discretion that we're actually leaving up to the person, up to those supporters, is the discretion to decide whether we're going to recognize this person as a full person with legal capacity in this particular transaction, or we're not going to. We're going to move into a substitute mode. So this is why I think we need to push this question of how we claim the moral status of another further. Because unless we can conceptualize that person is going to be recognized as a full person with legal capacity throughout their life by those people who are around them, close around them, unless they grant social recognition of that full right, then nobody else is going to be able to. And that's really why I think claiming the equal moral status of the person is essential to our conceptualization of this, because they provide the basis on which this person is going to be recognized as a full person when they go to the doctor's office, right? Because that's another sphere for recognizing the right to legal capacity without discrimination on the basis of disability. It's only going to be realized if that support network can help that doctor see that person as someone who has intentional action from which these consequences should flow in terms of having this surgery or not having this surgery. So that takes real work. And that's when I interview people, and in studies that we've seen, that's real work. Trying to convince that doctor that my gesture means this, and therefore these things should follow, and that's the basis of supported decision making, not a reason to say, well, in this case, Michael doesn't have capacity, so we'll make the decision for him. So I guess just to conclude, in order to realize the aspiration or the articulation, the recognition of those rights in the convention as we've got it, we need to conceptualize the various levels at which we need to mobilize the social recognition of those rights, or they're not going to be real in people's lives. And for many people with profound cognitive, intellectual, psychosocial disabilities at different stages and moments in their lives, the only basis for social recognition is those who know them very well. So we need to protect that space, we need to acknowledge that space, and use it as a bridge to mobilize broader and broader levels of social recognition. I was thinking, just to close now, I was thinking, about what will happen when the committee provides its response to Canada's report on the convention on 12, let's say. What will come back, hopefully, will be an analysis of where there's a gap between, Article 12 and the right to legal capacity. But as we talked yesterday also about how we apply international law in Canada, what that will really mean, what that report will be, it will be a space of social recognition, which is at the international level. We'll all read the report and we'll use it, we'll try to go to governments, etc. But it doesn't actually operate in the Canadian context, because we haven't mobilized the system of social recognition sufficiently within the Canadian context for that to be real. All that we can say, and all the courts will say, is we take the report into account, we take the interpretations of the court into account, but it's only at that level of the convention in international law that the people that I'm talking about this morning are going to have their rights recognized and actually live. They still won't be realizing them in the doctor's office fully unless we can put these systems of support and validate them as supported decision making, not as some discretionary kind of management between support and substitute. Okay, I think I'll leave it there.